Welcome to the Men's Divorce Podcast, brought to you by the domestic litigation firm Cordell Cordell. I'm your host, Sean Garrison, editor of dadsdivorce.com, and I'm joined today by Cordell Cordell Managing Partner and CEO Scott Trout. Scott, thank you for joining us today.
Hey, thanks.
On today's show, we're discussing the different issues that dads face when trying to obtain primary custody of their child. So to start with, Scott, can you kind of talk about when a client approaches you who is a dad and wanting to obtain custody, what's your typical response? I ask this because historically the courts have kind of tended to favor mothers in custody cases, and I'm wondering if fathers, do they still have that sort of uphill climb?
Yeah, so when guys come in the office, they'll throw the word around custody pretty loosely because it means something different to a lot of people and the varying laws across the state. So the first question is simply, okay, you want custody, what does that mean to you? And I'll really press them and ask them, what do they want? Because I'll explain that custody is really a label. Specifically, and we can talk a little bit about the differences later on in the show, the difference between physical and legal. And so I start there. Tell me, what do you want? What's going to make you happy? And I'll try to play into that meaning of I want custody. And the reason we do that is because guys are at a disability when it comes to seeking custody. And whether or not that is what I'll call primary or the most of the time. But I try to get them away from those stereotypical roles and using the tag of primary custody. Because guys can have, and I'll explain to them, hey, you know what, I can create a schedule where you have 50-50 time, but mom is the primary custodial parent. And if you can get over the notion that she has a label, because all that matters is time, then we do that. And that's kind of really where we start. That's kind of the approach. We try to make sure we just figure out what the client wants.
Sure. And you mentioned it there, the different types of custody. Can you go into the definitions of those and just explain what kind of the differences are?
So along those lines, when we talk about what do you want, we do break it down. Let's talk about time and let's talk about decisions. And those are the two differences. No matter where you go throughout the country, there are different labels for those, but they're universally two different roles. Primary custody, sharing time, that is the physical amount of time you spend with your child, whether it's overnights, daytimes, dinners, lunches, holidays. That's what I call the physical part of your custody situation. And then I usually tell guys what they really want to focus on is the legal part as well. If we can solve and make them happy with the time they spend ignoring the label, then we want to focus on what's called legal custody. And that is really being dad. That is the joint decision-making about the major decisions on health, education, and welfare. So choice of doctor, whether you have a surgery, a major medical treatment, a choice of school, private or public, choice of a high school, choice of college, continuing those studies, whatever that may be, those are the major decisions that you want to be a part of, that you must be a part of. So we implore guys to make sure that they don't discount the legal side, that they really focus on making sure that they have at a minimum joint legal custody so that mom and dad just are mom and dad. They may not be in the same home or under the same roof, but they should continue to what I call meet, confer, and agree on those major decisions that affect kids' lives. And so those really are the two, from a legal standpoint, the types of custody that you'll see. And then there are variances on the physical as it relates to the amount of time.
Right. And as an attorney, what are some of the steps you do when you're preparing for a case in which your client is trying to gain custody? What factors are you concerned about that a court's going to look at when kind of making that decision?
So the first steps really are to counsel clients. They come in the door. We want to talk to them about what has happened in history, and what can we do to prepare them to achieve their goals. And so really is we have to break it down. Many guys come in and we talk about their case in windows. Instead of looking at it as a panoramic view, it can be overwhelming. It's too much information overload. One of the most stressful, difficult times of their life. So we break it down into small windows. Let's talk about goals. Then we want to counsel them on how to achieve their goal. And that can include a lot of things, some proactive tips, be involved, parent-teacher conferences. The worst I've experienced is client gets on the stand and they're asked, what's your child's teacher's name? They have no idea. What size shoe did they wear? And they're stumped. What about their shirt? What kind of pants? What size are the pants? They don't know. Just give me one friend, and they can't answer it. Now, while that may be unimportant in the grand scheme of things, from a judge's perspective, it shows perhaps maybe a lack of concern, a lack of attention, a lack of involvement. So that's part of what we do proactively in some of the first meetings when we set some of the strategies to meet their goals. And so along those lines, it is parent-teacher conferences. Typically, if you're full-time employed and working, your way up the ladder in the corporation, you don't get a chance to go to parent-teacher conferences. Or you may rely on your wife who's a stay-at-home parent. But it's time where you make those changes and you start attending the parent-teacher conferences, getting involved. The first thing I tell clients is shoot an email to that teacher tonight. Say, hey, how's Johnny doing? I noticed some of his homework, he got a C. Start that dialogue with the teacher and make sure that they know who you are, because I can tell you, I've seen teachers come in and say, I couldn't even point out Mr. Johnson in a lineup. I've never met him. I've never spoken to him. I've never heard from him. I've never dialogued with him. And so that's part of the proactive stance that we take with clients. It's in preparation. That includes things like doctor visits, pediatricians, dentists. Nothing worse than getting the notes, believe it or not, when your child goes to the doctor and the nurse triages your child coming in, just getting some vitals, they'll write down child presents with mom or child presents with both parents. All an attorney has to do is get those records, introduce them to show that historically, and we'll talk about kind of what are the things, what do courts look at. But that's the worst case scenario, is that you testify, oh yeah, I'm thoroughly involved and go to doctor visits, but get cross-examined with a record that shows that no, you don't. And so that's another issue, is taking the doctor, taking the checkups, going to the dentist, orthodontist, whatever it may be. Along those lines, know their friends, be involved with their friends' parents, engage them in the neighborhood, know who the neighbors are. Again, know the teachers' names, the assistants' names, the principal. And it sounds so basic, but know even the school's name. It is, or the room number, or the room color, like they have colors, like he's in the red class. It really requires a reflection of the things that you do and you don't know. And then we want you to record those, put them down in a diary, in a journal, and start, engaging in an active role. And it's all about knowledge base and having enough information so that when you prepare for achieving your goals, the court then will analyze it in terms of what those factors are. And I think you asked me kind of one of the things that the court may look at. And so everything I just talked about, while the states all have different factors as it relates to custody, there's a recurring theme in all of them. And I can speak specifically on Missouri just because I'm licensed here, has 8 factors. And the court's required to go down through all of them. Some of them are the wishes of the parents, the willingness or the likelihood of one parent to provide custody to the other, the extent to which a parent is engaged in the child's life historically, his interaction with siblings or other people that may be a big factor in the child's life. It could be as well as the location where the parent is living. So change of school may be a big factor. But interestingly, I always have a client that says, well, my child wants to live with me. So will that weigh in? And in Missouri specifically, which is very different than a place like Georgia, Missouri, it's the 8th and last factor in the court's decision, meaning that the court should give it the least weight possible. I'm licensed in Georgia, similarly, where kids, depending upon their age, it can be an absolute factor, and it can be binding on the court so long as the child's wishes are reasonably and legitimately based. And so those are some of the things the court's going to look at as we relate to preparing for your case and what we're going to present in your case, and then how the court will analyze those factors. But predominantly, questions are who's historically been the caretaker, and we work from there.
What role can outside witnesses, such as, say, a child's psychologist or a child's pediatrician, play in a custody case?
So, representing guys, you never want to get into a he said, she said, because you'll lose. Statistics will show you're going to have external evidence, external facts, something that supports your allegations, what your factual support is. And so it's often that we will tell clients that it's critical and absolutely necessary that you employ a psychologist, perhaps, someone who will do a custodial evaluation. So what they do is psychologists will come in with court approval, interview mom and dad, perhaps even interview the child or children, and then observe both mom and dad individually and collectively in terms of their interaction with the child or children, as well as provide some testing, some psychological testing, just some baseline things. And then they will make a report and provide ultimately a recommendation to the court as to custody. And they can only do that recommendation when they've interviewed both parents. So that's not the only way you can employ a psychologist. We've done it historically where we don't have a full evaluation, but we have a psychologist come in and talk simply about dad's relationship with the child, and then doesn't make a recommendation, but in a sense is making a recommendation because they're saying, I observed the child, I observed dad, their interaction is strong. It's obvious through their communications, through dad's behavior, that their relationship is very strong, and that anything different than what they're doing currently would be detrimental. So in and of itself, it's a recommendation. But you've got to have a psychologist on board if you want to have a chance at more than 50-50, especially if you don't have super bad facts like drug abuse, alcohol abuse. Those things are game changers in custody cases where you're still going to want an expert. But absent that, you're going to have a reason better than you just being dad. It's going to have to be coupled with facts where you're the primary caretaker, that there are certain elements in your life that will lend itself to the best interest of the child. Because all things considered, dads still face a battle. There is no 50-50, I think, consideration. It just is what it is. Even though the times are changing in which we see women are increasing their roles as being the primary breadwinner, and we see guys staying at home, and we're still fighting those stereotypes or what I call the traditional roles, and making sure we break through that, because judges, I'd say, still have a difficult time when we present a case where dad stays at home. Their natural reaction may be, well, why doesn't he go to work? And so our response is, well, you wouldn't say that to mom. And so employing a psychologist is just critical. I mean, there are a number of other witnesses, including pediatricians, teachers, whomever that you may have exposure yourself in addition to your child that you're going to want to come testify. Because again, when it's a he said, she said, you lose. So you want secondary verifying testimony or evidence from someone unrelated to you or who has no interest in your case. It can't be your best friend. It certainly can't be your parents or your sister. I mean, it can be. But the point is you don't want to rely on someone whose interest is aligned with you. A great witness is your spouse's parents. We've had that on a number of occasions where we call to testify the spouse's parents, and they come in and they testify for our client. That is a home run where, we can say, well, don't you believe your daughter should have custody? Well, actually, no, I think our son-in-law is probably a better parent. That's difficult. but it's huge. And then again, the drug testing, we talked a little bit about it, but if you're going to make an allegation of drug abuse, alcohol abuse, you're going to have an expert. You're going to have drug testing. You're going to have an alcohol expert come in. And then lastly, one of the maybe most overlooked potential issues of employing an expert is parental alienation syndrome. So we give these seminars around the country to guys for free. And every time, without fail, I'll ask guys in the room, how many have heard of parental alienation? And one, maybe two, the minority of cities I'm in, 2 people raise their hand. So if you're out there and you're listening, what is parental alienation, which I'm sure most of you don't know, I would Google it. It is, again, an overlooked aspect that I think occurs in probably 95% of the divorces. And in order to prove up parental alienation, you're going to have to get an expert, typically a psychiatrist, a psychologist, who can come in and provide some theory, some backup to this theory, because it's not yet a recognized standard in psychology, but it is being used among a number of courts around the country. And the best way, while you're hearing this, me describe it, is to describe exactly what parental alienation is. And it's easily described as this. You move out of the house, mom stays with the kids, you're coming over for a regular custody visit, and she doesn't answer the door. You know she's home, but she's refusing to answer the door. Your children don't know you're there, and so you leave, and the children ask mom, well, why hasn't dad picked me up? And her response is, well, I love you, but your dad has a new family, and he has a new girlfriend, and she has a child, and I'll always be here for you even though he doesn't love you. And I'm sorry he doesn't come around anymore, which, keep in mind, these are all lies. And that is so damaging to a child that it forever shifts the cause of the breakup of this family to you and only you. So that type of behavior reoccurs over and over, whether it be, why didn't dad show up for my birthday? Well, he did, but she's lying to your child, making sure to turn the child on dad. That is devastating. I have unfortunately seen it on a number of occasions for 10, 15 years of parental alienation, even during and post-divorce, and it's devastating. So in order to prove it, in order to use it, you must employ a child psychologist, someone who can testify to it, who has experience with it. And let me tell you, if you're unfortunately the recipient of it, and you're fortunate enough to find an expert, it'll be devastating testimony in a trial as it relates to seeking custody. So, those are kinds of all the sources. Just as it relates to custody, there are so many others as it relates to the other issues in family law, financially, property-wise. But when you represent guys, it's almost a must. It's an absolute. You're going to have a whole host of third-party witnesses, unrelated, including child psychologists.
Sure. And can you think of any other issues that guys might not think of that can complicate their case for custody?
So during our interview process, when guys come in and we talk about their goals, the question I ask them, and I tell them, look, I need you, 1, to think about it before you answer, and 2, I want you to be absolutely 100% honest, and even think of something that is so small that could be used. So the question is, what's the worst thing or things that your wife is going to say about you? A lie or truth? Whether she's telling the truth or whether she's telling a lie. What are those things? And I don't care what they are. And I always premise it by saying, whatever you say to me, it's not embarrassing. Whatever you say to me, I've probably heard. Because I probably for the last 10 years, there hasn't been a fact or an activity or an issue or consequence or whatever it may be in family law that I haven't heard. And so I said the smallest of things can be the biggest of issues. And so those are the things that you want to know. And it could be a past conviction for a client. It was a DWI. Well, he had a lawyer take care of it and didn't show up as a conviction. Still going to be used against you. Drug use, occasional drug use. Whatever, it may be legal in your state to use marijuana. still going to be used against you. A previous order of protection against a girlfriend or an ex-spouse, any family law related issues will come up and be used against you. I mean, they complicate it. And a judge is looking to a guy, and they have to be perfect. And it seems like an unreasonable, impossible standard, but it's unreasonable, but it's not impossible. We don't want the court to have any chance to deviate from hearing what our message is and hearing what your strategy and why you should achieve it. Side issues like a girlfriend. You have a girlfriend during the separation. It's a complication. It's, I always tell my clients, look, if you can deal without it, my recommendation is to not do it. It's a distraction from what the real issues are. My job is to do the same thing to your wife, is to distract the court from seeing who she really is. That would include even Facebook use, social media. Those are issues that can arise throughout. The recommendation is always never use social media during your divorce. I know it's cool and it's, everybody uses it, but it complicates it. I can take a picture that you post and turn it into something that it's not. We can create chaos in your claim for custody just by a post or whatever it may be. And so I think those are things that complicate it, not knowing the facts. We talked a lot about that earlier, about knowing everything about your kid, a day in the life, the classes, knowledge, or the lack of knowledge, the lack of information complicates your case. And then having friends, family members who have issues. You may be the cleanest whistle in the family, but if you surround your children or your child with people who, albeit related to you, have issues, whether it be criminal, people they hang out with, things that they do, things that they view, they read, whatever they watch, it could be a babysitter, not all those things. Again, distractions. So what you want to focus on is eliminating every distraction that you can conceive of that a court would look at and be interested in, and simply focus on your message. If you can stay on point, and it's not easy, but it takes practice, it takes focus, hiring competent counsel to guide you down that road to ensure that the court isn't distracted. Now, all is not lost if you have those distractions. What it means is, as I started this conversation, is answering that question as honestly as you can and as fully as you can. That is, who is it? What's the worst thing they're going to say? And then we follow that up with, what's the worst they're going to say about your family? Worst thing they're going to say about your friends? Is there anything in your history that I could come up with and use against you? Again, it may never be used. It may never come up, but it's information that's important. It's information that can be used against you. And if you lose the attention of the judge, then the case is over. That's just a huge factor as it relates to seeking custody.
And what about after the dust has settled and custody's been determined? How challenging then does it become for two ex-spouses to work together as co-parents? And what can they do to sort of help that relationship as they go along and try to raise their kids?
Every jurisdiction has what I'll call parenting classes. And I know that sounds corny. For example, here, kids in the middle or children's first. It really teaches you how to communicate with an ex-spouse and how not to put the kids in the middle. Because that is one of the things that can hurt the most, is either allegations subsequently on a motion to modify that you're using the kids or placing them in the middle of discussions in which are adult in nature. But it is something that's so important that I always talk about this, and that is you stay focused on your goal, and that is putting your child's needs over your disagreements with your ex-spouse. And it's easy for me to say that. But if you approach every conversation that talks about legal custody, major decisions, health, education, and welfare, And if you can say, I don't like my spouse or my ex-spouse, I actually hate her. But if you can put that aside and say, look, I've got to get through this conversation. And the only way to do it is to make sure that I'm civil, I'm appropriate. It can be a short conversation, direct. It is important that you do that. To put aside every disagreement personally and only focus on your kids' issues. Now, that doesn't mean you're going to, waving a magic wand and you're going to agree on everything. So what we do is we take that to the next step. So if you can get aside from who caused the breakup and what nastiness went through the divorce, how much money you had to spend to get the case resolved. And then what you do is every communication subsequent to the divorce that relates to the kids is confirmed in writing or had in writing. Again, avoid the he said, she said. So I'll tell my clients, if you had that phone conversation and you both agreed on an extracurricular activity, simply send an email that says, hey, thanks, I appreciate the call. I'm glad we got to agree and that we put Johnny in soccer. You don't want to say this is to confirm our agreement, because then she knows you're setting her up. The point is it's just a normal, friendly, hey, thanks for the call. I'm glad we agreed to put him in this. That seems less pressure or less obvious that what you're doing is confirming everything. But now you've created a historical document that can be used to show that it was contemporaneous with your oral agreement as it relates to legal custody. So, it's very difficult to co-parent, especially the very reason perhaps that you got divorced was you couldn't communicate. So it's educate, stay focused, confirm, and then lastly, we talk about recommendations with clients, and that is creating a diary or a journal, a day in the life of what happens. It's much easier when you go to an attorney and you have issues or concerns as it relates to custody, both physical and legal, as we've described the differences, to say, well, I kept a journal and I kept it contemporaneous with the event, meaning that when the event occurred, within reason, I went and wrote it down. Not a year later, I tried to reconstruct the events. You want to make sure that you did that you have this journal. A lawyer can go through it, and then you can use it in court to show that it was a historical recordation of everything that occurred. And then I would do pictures. Keep yourself pictures. Show yourself, not just of your child, but you with showing exactly what's going on so that there's, issues as it relates to the custody, how to co-parent, what's going on. You can look at your demeanor in the pictures and then stay involved. I know that, we talk about in the very beginning how we become proactive, but that has to stay post-divorce. And that includes doctor visits, teachers, staying actively involved. And for many guys, they're already involved. But it means stepping it up. You have, in some states, 18 to 22 years of dealing with your ex-spouse to try to raise your child. It's a long time, especially with someone you really don't like or don't agree with or don't get along with. Now, that's not the majority, but using an extreme example. So it is continuing to learn how to communicate with someone like that. And then making sure, and I always tell my clients when they leave, from here on forward, what you're doing is you're playing defense. You're assuring that to prepare a case in the event that she takes you back to court, that you have enough evidence, you have enough facts, that you can defeat any motion that she brings against you. So you can't, relax and rest necessarily. It's always a matter of preparation and keeping things and documenting things. It really is, and it saves attorney's fees. The more you do for your client or for your attorney, the less expensive it becomes, the less fact gathering, the less things that the attorney has to do to try to reconstruct a defense for you, or even perhaps being proactive. So when it does settle, it really is very difficult. So those are really the tips we tell our clients. But if I'm going to break it down to one thing, it's communicate and confirm in writing every single time, and then save it. Just don't leave it on your computer. I'll print it out and I'll keep it in that diary or in that journal. That really, in the cases that I've dealt with on subsequent contempt motions, motions to modify, have been case savers and winners. We've had clients that have been so organized, they put in a binder, a 3-ring binder, every single communication. And it was organized by month, by year. It made life much easier and led to a good, easy victory.
Are there any other general tips you can think of to give guys just pertaining to custody?
I think it's gathering as much information as you can. I mean, most guys, when we do these seminars at night, I always talk about doctors had it right. When they begin to specialize in oncology, pediatrics, whatever it is, very specific areas of medicine, they have it right, and they're trying to do one thing well. So when guys are faced with, a particular issue, whether it be family law, I always say it's like getting diagnosed with cancer. It's a devastating diagnosis, and you're going through divorce or you're going through post-divorce issues. So that means you go on the web and you gather the information, you research your topic, you talk to other guys, you go to dadsdivorce.com, you read the articles, you get the books, 10 Stupidest Mistakes Guys Make, and you just fill your brain with as much material as you can, because it does equip you to make the right decisions, because every decision you make has a consequence. And many guys aren't, they think that, it's a minor thing I'm doing, and they discount the consequence or how the opposing counsel can use that action against you. And so education and knowledge, it's the phrase knowledge is power. And it's so true. I mean, I can't think of an example. I know when people get diagnosed with something or they feel bad or they have a symptom, they're immediately going to the web and they're researching it. I think guys don't do that enough in family law. They don't research enough. Now, there's a lot of bad advice out there, but it is about accumulating solid material, getting on the web, finding out where lawyers who only do family law write articles and reading them, and then having that consultation. You can't have a consultation soon enough. I can tell you many, many guys I meet with, they come in and they're just planning. It may be a year down the road, maybe 2, or maybe just a few months. But it is staying on top of it, making sure that you get what you need, because the laws change. I mean, not only for us, we have to stay on top of it, but for clients. So you should continually see what's going and what's changing and how often and how it affects their case. In fact, there was a Supreme Court case that came down just today on family law. So it affects a lot of guys. So you want to make sure you stay on top of that knowledge and consume information on family law. And that's what, probably the biggest tip I can give guys.
Sure. Well, thank you so much for joining us today, Scott. I'm sure there are a lot of fathers out there who will find this information really useful.
All right. Thanks a lot.
For more tips to help with your child custody case, be sure to check out CordellCordell.com, as well as Dad's Divorce and Men'sDivorce.com. You can also download the Men's Divorce Source app on the App Store. I'm Sean Garrison, editor of DadsDivorce.com. Thank you for listening.